Hello, everybody. My name is Tomás Vázquez Rojas. I'm a research assistant at the Cyber Justice Laboratory at the University of Montreal. Thank you for joining today's webinar, Helping Ourselves to Justice, Perspectives on Legal Self-Help. We have the pleasure of welcoming Alyse Bertenthal, Assistant Professor of Law at Wake Forest University School of Law. The Cyber Justice Laboratory is a research center that explores the interplay between new technologies and the law. We are currently conducting the project Autonomy through Cyber Justice Technologies, funded by the competition of the Social Sciences and Humanities Research Council of Canada. Our project brings together more than 50 researchers and 45 partners dedicated to the use of technologies and artificial intelligence for the prevention and resolution of conflicts. Over the coming weeks, we will continue hosting the series of aligned activities started last year. These activities gather the opinions and experiences of legal experts from around the world on recent events. From ethical issues to crisis management, including analysis of the achievements and failures of technological shifts in the legal field, the laboratory will present varied and relevant content. Stay tuned by checking our social networks and visiting our website, cyberjustice.ca. For those joining us for the first time, welcome. If you experience any technical difficulty during the activity, please exit the meeting and re-enter using the link provided. You will notice at the bottom of the screen the option Q&A or Q&R for French-speaking users. We invite you to use this option instead of the chat window to ask your questions. The chat will be not allowed. A member of our team will take your questions as we go along, and they will be asked to our presenter at the end of the web conference. Finally, for those who wish to receive a certificate of participation for your continuing education, we will send you a link through the chat window during the question and answer period. That will be the only time the chat window will be used. Without further ado, let's start the presentation. Professor Bertenthal, over to you.
Bonjour, merci de m'avoir invité. C'est un grand plaisir d'être ici avec vous. And it's been a long time since I've spoken French, so I'm not going to subject you to any more. But truly, I'm very excited to be here and to have this opportunity to talk about a really important subject in access to justice, legal self-help. Now, by self-help, I mean litigants who represent themselves, doing all that's needed to litigate their case. So before I get to this question of what legal self-help is and how it's done, I want to lay a little bit of foundation about why such self-help is necessary. Now, I'm a scholar and a researcher in the United States, so the statistics I'm going to show you are unique to the American context, but I suspect you'll see similar patterns in Canada. So unlike criminal cases, there's no right to a lawyer in civil litigation, and attorneys often are financially out of reach for many of the low and even moderate income litigants who do not qualify for the limited free legal aid services that are made available to civil litigants. As you'll see, there are many, many, many more people who need a lawyer, a legal aid lawyer, a free lawyer, than there are people who can generally afford these private lawyers. The average cost of an attorney in a small American city is roughly $100 to $200 per hour. That can rise to $200, $400, even higher in larger cities. And of course, this graphic is showing that even those who qualify for free legal aid, there just aren't enough attorneys to serve everyone who needs one. Let me give you some general statistics about what all this means for people who want to file or need to defend a case. 33% of civil cases in the federal district courts are filed by pro se litigants. Pro se litigants are litigants who don't have an attorney. These pro se litigants file more than 50% of all federal civil cases. In California family courts, more than 80% of the petitioners for dissolution, for divorce, are self-represented. In California unlawful detainer cases, more than 90% of defendants are self-represented. More than 4 million court users in California, which is where I primarily did my research, are self-represented. So you can see this isn't a small percentage of the population that's self-represented. This is a tremendous amount of people. And in some courts, these landlord-tenant courts, for example, almost all of the litigants are self-represented. So we recognize that there's serious obstacles facing these unrepresented litigants. Courts, government agencies, and lawyers have advocated for new models of legal assistance for these litigants who don't have lawyers, Simply having lawyers for all of them is not feasible, and it just can't be done. So they're saying, what else can we do to help them? And so in the US, a legal self-help, this idea of helping litigants to help themselves, is what we might say is the fastest growing segment of these kinds of new ideas of service models. There's other legal assistant models such as lo bono or unbundled legal services that don't really offer any kind of form of legal representation. And similar to those, self-help focuses on providing litigants with information and resources needed to navigate the rules and regulations, such as meeting filing deadlines or formatting their papers, that are necessary to file or prosecute or defend their cases. So these self-help services aim to provide legal education and assistance to the hundreds of thousands of litigants who don't have lawyers to represent them in civil legal disputes. Now, given what they do and don't do, these legal self-help services might be more aptly described as help to self-help. We're not going to represent you, we're going to help you represent yourselves. And that brings me to the subject of today's talk. During the next half hour or so, I want to cover a couple of things. I want to describe for you what providers of legal self-help services think that they're delivering. I then want to talk about my research into legal self-help, in which I did a deep ethnographic dive into legal self-help practices to uncover the language and practices through which self-help providers are delivering their services, and to what effect. I want to spend the bulk of our time talking about some of the key findings from the research, findings that I think will illuminate how we use, or how we as attorneys can better help litigants to self-help. And then I want to look a little bit to the future and think through with you how we can take this self-help model, which has thus far been primarily executed in courts, and use it to inform more and grow kind of more grassroots attempts to access justice. In that thought experiment, I'm going to talk specifically about environmental justice, which often happens far outside the courtroom. So let's start with some basic ideas about legal self-help. In an essay reflecting on the role of lawyers, legal philosopher Roscoe Pound likened law to a machine, a vast apparatus of social control. The lawyer, he said, could be analogized to an industrial engineer, someone who's tasked with tuning and refining the law, one whose calling it is to assist in the administration of justice, one whose calling it is to make a social process or activity achieve its purpose with the minimum of friction and waste. Now, in my research and fieldwork on legal self-help, I was struck by this degree to which individuals in both the public and the private spheres embrace this logic, if not the explicit analogy, of Pound's lawyer as a social engineer. The clearest instances can be found in articles and professional reports that are produced by legal advocates and legal academics, but also in a vast array of promotional materials created by and about self-help providers. So I want to show you a couple of examples. These are excerpted from sources explicitly concerned with legal self-help services. In establishing a do-it-yourself center for self-represented litigants, this is a court advertising its self-help center. It says it's borrowing a page in customer service from Home Depot, a hardware and building supplies giant. Court officials say they take Home Depot as their model because the home improvement chain is founded on the theory that people can do complicated things with the right advice. Here's someone who's talking about their clinic. Through building relationships, we hope to even further extend the empowering reach of the self-help unit. The familiar stories of heartbreak and broken relationships will probably never end. Clients will keep calling, the tears will keep flowing. That part of the story we cannot change. But through this self-help center, we can offer a way to positively alter the ending to each of these stories. This is a promise given by one of the self-help centers. Another self-help kind of center, the California Courts, which sponsors clinics designed to help litigants help themselves, says, the pro se litigant has an opportunity to be seen by a couple of attorneys as part of the clinic. It helps the pro per litigant from the standpoint that they are able to understand the process, and that by them understanding the process, they're able to proceed with their matters in an efficient manner, which also, by the way, helps the court. So these images of the helpless, hapless, even heartbroken and tearful litigant rescued by lawyers who operate with an almost corporate-like efficiency are pervasive throughout these descriptions of self-help legal services. Taken together, they link legal assistance and access to justice in a very particular way. By giving the right advice and empowering litigants to understand the process, go in more intelligently. Lawyers manage rather than to represent the litigants, to help them understand the process, to positively alter its conclusion, enabling to proceed in an efficient manner that also helps the court. I think this gives us a very complete picture of what people think the goals are of these self-help clinics. Self-help services are aiming to ensure that litigants comply with complex and specific rules and have the opportunity to tell their story, but also to help the judges who hear these stories to be sure that they're doing justice in a particular case. And that's the perspective of self-help from those who are providing it. Now, I was interested in what really goes on in these self-help clinics. So I went into a self-help clinic to actually study what goes on there. I'm an ethnographer, which means I gather information by observing people and what they do in their natural environments. It's a research methodology called participant observation. And this is where I went to do that observation. By the way, the quote that I just showed before was Associate Justice Zellin, who was the head of this clinic where I went to study. And she's giving a familiar story of, we created this clinic to create an opportunity for justice. And this clinic you'll see here is an appellate self-help legal clinic, meaning they work on appellate cases. It's located actually in the California Court of Appeals in Los Angeles. It's a modern concrete building, downtown, 19 floors. It houses state government agencies and offices. It's also where the Court of Appeal for the Second Appellate District is. This is the largest and most populous of the state's 6 appellate districts. Now, this clinic was sponsored by the Court of Appeals, and it's given space in the courthouse. When a self-represented litigant will file a notice of appeal, the court clerk at the trial court or the Court of Appeal clerk's office will tell them that there's this thing called an appellate self-help clinic. So litigants come to the clinic for a variety of reasons, usually because they've received a letter or an order from the court and they need to respond to it, or because they need to file a motion or a brief in their own case. Now, this particular clinic is run by an attorney from a local public interest organization. Sometimes there were volunteer attorneys, but this attorney, Lisa, was deeply, deeply invested in the clinic. And I think I had a hard time in some ways ceding control. So most often when I was present in the clinic, it was Lisa who was there. I will say that Lisa is a very accomplished appellate advocate. She's often listed on the best of lists that kind of circulate around, these best of attorneys under 40, best of attorneys who do appellate practice. She's an incredibly accomplished appellate attorney, and she ran this clinic two times a week for full days, in addition to keeping a full-time caseload at a public interest organization, an organization that, even though it's fairly well-resourced, nonetheless doesn't have a lot of staff or funds. So she's doing a tremendous amount of work. I want to give you a feel for this clinic by walking you through it, and then I'll talk a little bit more about my research there. So this is the clinic entrance, and if you can see this sign, it notes exactly who's allowed to use it. It says the Public Counsel, which is this organization that runs it, for unrepresented indigent litigants. And it's open Monday, Wednesdays, and Fridays from 9 to noon and 1 to 3. So right there at the very threshold, you have a sense of whether or not you belong or not in that clinic. Now, as soon as you walk through the door, you come into a clinic waiting room. And it's a comfortable space with big, comfortable chairs, but it's very clear that this is a formal space. The pictures that you see in the background are pictures of judges and their clerks. There's a security guard who's always present at that desk. There's usually a sign-in sheet where you sign in and then wait your turn. Now, this is Lisa's office. This is Lisa who's sitting here, and she's here counseling 2 litigants. And it's just a regular kind of space. There's a large desk. There's a computer not shown where Lisa is, and a couple of pictures. Now, I want to show you just some images of the litigants who come here. Unlike these crowded cubicles in most local self-help legal clinics, this space is comparatively luxurious. Attorneys can meet with the litigants one-on-one. It's not a large room where you're hearing everybody else talking and trying to sit over each other. You're not separated by glass. It's enviably spacious. It holds a desk with a computer. It holds a printer, a small bookshelf, a file cabinet in which Lisa stores legal treatises and references, and a second desk with a chair on either side for Lisa and the litigants who come to see her. Now, I was in this clinic for approximately 6 months, and I observed more than 100 different meetings. I'm particularly interested in how interactions manifest through language and other forms of communication. So I recorded by audio or video all of these meetings. And I'll talk about how I analyze these in just a bit. But my data is comprised of notes that I took contemporaneously as I was observing, semi-formal kind of interviews I had either with Lisa or with the litigants during pauses in the conversation between the two of them, and in transcripts of these recordings, transcripts and also video recordings. So I want to give you a closer look at the litigants who made use of this clinic. In terms of demographics, these are certainly the litigants that the self-help category is designed to serve. To use the clinic, they can't have an attorney. They have to meet a certain, be below a certain income threshold. And that's all checked and validated before services are actually provided. Now, these litigants who come to the Appellate SelfHelp Clinic present an interesting paradox. They are by definition dissatisfied with their prior experiences with the law. After all, they lost their case in trial court. But they continue to use the law to remedy what they see as a past wrong. So many of them complain about the toll that litigation has taken on their health, their finances, their families. They disparage, a lot of times, the trial court judges, who they called unfair or even corrupt. And they despaired the prospect of having to write and speak in what they frequently claimed was a foreign language. Yet despite all of these negative outcomes that they've already experienced, the negative experiences they anticipate having in the future, the litigants at the SelfHelp Clinic were adamant in continuing with their cases on appeal. And in their discussions with me and Lisa, the litigants offered several different explanations for their persistence. Many were angry, many were determined to right what they perceived as an institutional wrongdoing. Anthropologist Sally Mary has observed in her research of working class Americans' use of the court similar dynamics. She says there's both a power and a danger in the use of courts. There's a power in wielding a potent weapon, but there's a danger of losing control of that weapon, of initiating a process that can't be stopped. So litigants who lost their cases in the trial court have experienced this danger firsthand. They went in, they thought it was a weapon to get justice, and they ended up losing, and that felt something like they were powerless. They complained about the total litigation had taken their health and their finances. They were angry and adamant about righting what they perceived as some kind of wrong. So for example, in the midst of a lengthy tirade against the judge that had refused to reward her alimony, one litigant told Lisa, you know, the definition of insanity is doing the same thing over and expecting a different result. But when they keep just pouring the earth on top of you and you have 3 small babies at your legs, it's a difficult situation for a woman to find time to come down here and wrestle with these court proceedings. I just have no sympathies for these. I'm just disgusted by it. I'm so disgusted. It's so upsetting. There's so much after 4 years. It's just ridiculous that they did this abuse, this second abuse. This idea that litigation or that what's happening in court feels like a continuation of the abuse that they've already experienced presents a really interesting paradigm for these litigants who are then continuing to fight against it. And some litigants actually see this appealing process as an achievement that somehow can be realized separate from, or even despite the legal outcome, maybe a way to regain some kind of power. So as one litigant who was appealing a temporary restraining order told me in response to my question about why she was appealing, she said, look, the law is for the doctors and the lawyers. They don't have any respect for the public. But she still believed that justice would be served. Because she said, even if I lose, I could say, hey, I tried. I'm still a winner because at least I tried, you know? And if I don't, then I'm totally a loser, you know? So this idea of if I just give up, then I've just completely lost, I think motivated a lot of litigants to come and continue pursuing some form of justice, even if they didn't expect that they actually would find what they needed. Another litigant admitted in response to that same question, I know I'll be happier if I don't continue to do this. But my fear is that if I don't do this, I will become very cynical. You had your chance and you didn't do anything. You know, if the system didn't work for me, I will hold resentment. So I take it as far as I can, I did my part, and then I can sleep. Still, others maintained a hope that by appealing, they might achieve some kind of abstract value, such as justice or truth. One litigant, for example, explained her decision to appeal as a quest for the justice that she had been denied in the trial court. And all I could do in the trial court hearing was answer yes or no. I never got a chance to really speak. And if I tried to explain, I couldn't defend myself in any kind of way. Well, when the judge made the judgment, I knew I wanted it over, and yet something was just hunching me inside. And I said, this is not justice. It wasn't justice because I couldn't tell my story. Another litigant expressed a similar sentiment, insisting in response to my question about why he was appealing that there's inequity in the system, that it needs, quote, a big, big overhaul. And more to the point, he said, this is just stupid. Yet he conceded that he'd been litigating his divorce for 7 years, sometimes on his own, sometimes with the assistance of an attorney he had occasionally hired to represent him. Even though he maintained that attorneys, quote, don't help, and the system is, quote, stupid, he told me he would continue to appeal because it's wrong. It's so blatantly wrong. He expressed the conviction, however inexplicably, that he would succeed because the truth will come out. These are his words. So several months into my study, as I'm sitting in this clinic observing everything, I tried to pin down Lisa, the attorney's own view on the import of the services that she provides in the Appellate SelfHelp Clinic. Well, it would be helpful, she told me, to be able to craft strategy, to draft briefs for litigants, to do the typical services that attorneys provide. Testing out one of my hypotheses, I asked her, but don't you think that even if litigants aren't winning their own cases, and even if you haven't been able to fix all their paperwork, that there's still something of value in having the clinic? Maybe there's something important that comes out of the conversations that you have with people? Well, Lisa considered this for a moment and then half-heartedly said, well, I guess so, but sounding entirely unconvinced. So I really want to understand what exactly these litigants and Alyse are appealing to, how they're shaping these appeals. And so this drew me to examine more closely the clinic practices, to see what happens as attorneys and litigants engage with each other and with the effort to provide or partake of help to legal self-help. Now, these efforts manifested in 2 significant ways. One was primarily linguistic, in which Lisa and litigants would vie for understanding of their particular worldview. And I want to just show you an example of this. The other was driven by and focused on the construction of writing to convey these varying worldviews. Then I'm going to provide some examples of what I mean by each of these efforts. And my analysis is going to give additional insight into the dynamics of, I think, what happens in this legal self-help clinic and the challenges of practicing what we see as help to self-help. I want to start with some conversations. So,
I mean, it's I have to have an opposition by next week, but they'll probably have an answer by me for next week then. Just specific case or?
Well, your opposition is due May 6th. But you could file it, obviously anytime this week. Or
I don't know what to say.
Right, that's the issue. You would want to be able to make some argument.
I have issues.
Well, I mean, and like Frank was saying, you in an opposition, you would be talking about this motion, not about your case, but about why you think this motion is wrong. And in the motion, all they're saying is your notice of appeal is late. So that's what you would have to be arguing about. You would hopefully, if you file an opposition to this motion, you would be trying to explain why you think the notice of appeal is not late. And I just
understanding the rules, I mean, it's like, one company I had 90 days, one company had 180 days, and you told me I had 60 days. I mean, it's paperwork. I said it's fucking shit. I don't know.
Yeah, and that's perfectly understandable. It's just not going to cut it with the Court of Appeal people.
So I want to start with that. Most of what I'm going to be discussing is going to be in 2D. It's going to be taking transcripts and walking through them with you. But I wanted to give you a feeling of what it feels like to actually be in this clinic space, because I think you get a lot from watching not just what people are saying, but how they're interacting. This moment of levity, of humor, I have issues, and this shared laughter, forming connections that are things that I think are really important to describe as we talk about how legal self-help is executed. I'm not going to analyze this particular conversation in detail. I'm going to walk you through a particular litigant that I'm going to call Michael. And the interaction I'm going to walk through with you takes place soon after Michael has entered Lisa's office. He introduces himself. In analyzing the transcript of this interaction, I want to show how Lisa is going to define self-help, to encourage Michael to accept responsibility, not only for his case, but also to accept responsibility for guiding the conversation through which he's seeking assistance from Lisa, teaching him, in a sense, what it is that she can and can't do. So this excerpt reflects precisely this type of negotiation between Lisa and Michael. Now you'll see up here, Michael initiates his turn by setting out the rules for the conversation that will follow. He says, I'm just going to say that I'm going to give you privileged information. I'm going to be talking about privileged information, and I don't want disclosed or communicated. That word communicate means email, letter, any contact with a company or with their attorney, Joe 1 through 10 or anyone related to them. Nothing regarding the information I'm going to discuss here, okay? And so by calling his information privileged, Michael's invoking a powerful legal term that indexes this cornerstone of the attorney-client relationship, the duty to keep communications confidential. And through use of this specialized term, Michael's asserting himself as an insider who knows what lawyers call information that can't be disclosed. He expects Lisa to understand this special meaning, and then he goes on to define what kinds of communication he means. He leaves privilege unexplained, of course, because he figures that they're talking at the same page. He's putting himself at the same level as Lisa. And indeed, Lisa appears to understand the import of this reference and the expectation of her that it suggests, because she answers Michael by explaining she is not his attorney. Okay, let me just explain, she says, I don't represent people who come to the clinic. I don't give legal advice to people who come. So I don't become your lawyer. And we don't form an attorney-client relationship here. So through this explanation, Lisa's correcting Michael's attempt to assign any kind of significance to her identity as an attorney. Although she's a lawyer, she's not Michael's lawyer. And this key fact means that privileged information carries no special import in the clinic. It doesn't impose any kind of special responsibilities on her. Now, in the very next turn in this conversation, however, Lisa is going to indicate that she wouldn't disclose the information in any case. Not that I would, she says. Right. I mean, there's no reason why. I understand. But I don't have that duty that a lawyer would have to a client because I'm not a lawyer. So there are certain kinds of privacy expectations you can have, but you can't have these professional expectations of me. Now, she essentially agrees she's not going to start this conversation with others. So why is she continuing to state that she's not Michael's lawyer? One possible explanation is that Lisa is explicitly disclaiming this attorney-client relationship because in California, such relationship may be formed if the litigant has merely a reasonable expectation that exists. So Lisa needs to make sure that there's no such expectation. She cannot serve as his lawyer. There are 2 poster-sized signs in Lisa's office that make this waiver already clear. And yet, Lisa is not convinced that those signs are sufficient. But another interpretation of Lisa's repeated kind of disclaimers that she's defining for Michael, what it means is that she's defining not just their relationship, but she's trying to define for Michael what it means to be engaged in self-help. That no one is required to do anything for him. She can, but doesn't have to, take care of him. Now, this critical move that Lisa makes is to separate herself from her professional identity as a lawyer. She tells Michael, I as a person, I as Lisa, wouldn't reveal the information because I personally have no reason to do so. But she also makes clear she has no professional obligation to keep the conversation confidential. Instead, she's insisting that Michael can't count on her. He has to make his own decisions about what to say or to do. So immediately she's activating, she's initiating this process of self-help. As much as this might be about distancing, I think it's also this process of activating him to take responsibility for managing his own strategy, his own well-being. By declaiming her duty, Lisa's activating Michael to volunteer as his own attorney, to make his own decisions, to create his own opportunities for the justice that he's seeking. Now, once activated, however, Michael still needs help to self-help. Much of what Lisa does is educate Michael and the other litigants who come to see her. There are a couple of stages of this process, usually beginning with an assessment of the issue, which is then followed by information clarification. So for the sake of time, I'm going to skip the details of those parts where Lisa's trying to figure out what's going on in the case. Usually she looks up what happened at the trial court. Essentially, she realizes after all of this that there's no file from the trial court. She struggles to figure out who this litigant was and what he needed. So after additional questioning, it appears that Michael's case was in the Federal Court of Appeal, not in the state court. Although this is no longer within the purview of the clinic, Lisa wants to make sure Michael will have what he needs to file his appeal. She asked, did they send you something about doing a brief if you don't have a lawyer? And Michael says, no, they didn't send me anything. And Lisa's a little bit befuddled, and Michael says, I'm just trying to feel my way, I'm having an idea, you know. I'm just trying to understand what an opening brief is. It's like telling your story and telling the judge what you want to know about your case and why you think your appeal should be reversed. So without necessarily responding in any way to Michael's kind of explanation, this idea, this narrative about what happened with his brief, Lisa just goes to her computer, prints a page, and hands it to Michael. She explains that she's just given him a packet that'll explain what Michael needs to do to write a brief without a lawyer. And now that she's assessed what he needs and given him kind of information in the form of this paper that's printed from the computer, she directs him to review these materials. She doesn't answer his questions about what he thinks the brief is about. She's educating him not only about what to do next, but also helping him to understand what issues he should be concerned with in the first place. In this way, she's not only empowering Michael to self-help, she's defining and directing the specific way in which he should undertake this task by reading the paper she's given him, not by asking her questions. Now, in this discussion I've just presented, I followed a conversation between Lisa and Michael to show how they jointly negotiate what needs to be done and who should do it. Many interactions in the clinic don't fall within such a neat dialogic framework. It's not a back and forth. Instead, as I'm sure you've all experienced, litigants offer lengthy narratives in which they attempt in one way or another to explain some aspect of their case or their claim. In this next section, I want to examine one such narrative in which Michael is explaining what he understands to be the facts of his case, after Lisa suggests that he should go to a different legal self-help clinic to get help. So here she's explaining to go to a different self-help clinic, and he says, well, the judge didn't have any power. He was just talking. The bankruptcy court loses jurisdiction. Number one. Number two, on top of that, when the court has given you a relief from a stay related to the estate, they really lost jurisdiction. And he says, I'm a Bible man, and we have a figure in the Bible. I'm going to go New Testament on you. I believe in the one guy who went to this man and said, come out of there, come out of there. He was possessed by a demon, and the demon reared up and looked at the man and said, Jesus, I know. He said, I know him. Now, Paul, I know of. Now, he didn't say he knows Paul, but he knows of him because he doesn't have that type of relationship with him as he did with Jesus. But then the demon goes, but who are you? You have no power. You have no covenant. You have no authority. I say this to say this. The judge, abandoned properties. The trustee, once he abandoned it, he can't come back and say, oh, you made a mistake. It's too late. It's gone. You can't come back and bring it back. Once a property is abandoned, you cannot reverse it. It's abandoned. It's always abandoned. And, I think this is a really interesting narrative. As attorneys, our first thought is, what in the world do we do with this information? Is this related to the case? Is it not related to the case? It doesn't tell me what needs to be done. I don't know what the answer is. But as I saw again and again, these narratives are becoming a way of negotiating much more than a case. They're a way for the litigants to revert to self-help in their own terms, a way of rejecting this framework that Lisa is imposing on him. You need to look at this paper to know how to do your brief. You need to go to another self-help clinic that can deal with your case because it's in federal court and I only deal with state court. This is a way of asserting, I'm going to deal with it in my own way. So this is a colorful imagery of an exorcism that's gone awry. And Michael here is suggesting that only certain people can issue demands. This authority to issue demands depends on prior recognized relationships between the person who commands and the person expected to obey. Now, Jesus, I know him. There I can obey, but I don't know you. Who are you? Why should I listen to you is what he's saying. Knowledge and power are intimately linked here, and they're woven together in surprising and somewhat unforeseen ways. Power doesn't emerge as an entirely active force. It appears to reside in the person whom authority tries to subordinate. Michael uses this story to argue that the trustee, in his case, it's a bankruptcy case, like this exorcist in his story, was entirely unknown and thus had no recognizable claim to the property possessed by someone else. Because he's unknown, the trustee has no power, no covenant, no authority. He can't order any double, whether it's the judge, the law, or Michael himself, to obey him. So stories such as this are not only significant for what they express, but also for how they function within interaction to change the dynamics of this participation and agency. As it argues with questions of external authority, Michael's narrative performs its own methods of thought and expression, for which it necessarily claims a kind of authority as well. This movement of Michael's response to Lisa's basic question of what happened involves the transfer of language, not just from one person to another, from one kind of language to another, from one kind of world to another. Michael begins in this legal world in which it's possible to talk about courts and jurisdiction. He moves through a world inhabited by devils and the apostles, and ends with his own personal experience of lost property and missed opportunities. Within his response, knowledge features as the mechanism for forging power. But knowledge also becomes the basis for assembling power to tell a particular story in a particular way. So Lisa focuses on specific procedural steps, and Michael invokes his knowledge as the Bible man. Moreover, by offering this story, Michael invokes his knowledge to reject Lisa's implicit assumption that someone can understand his situation merely by plugging in a case into an online form, by looking it up on a computer, by pulling up a piece of paper from a file. We might read his story as an evaluation not only of his prior case, but also a commentary on the ongoing conversation with Lisa, this process through which Michael is gaining information about asserting his legal claim. Knowledge, specifically the choice between different kinds of knowledge, legal, technical, rational. This kind of knowledge functions as both a stake and a weapon between those who, like Lisa and Michael, are in competition to say what access to justice exists, who has the power to open it up, and through what means they might do so. Now, this meeting between Lisa and Michael confronts us with the tensions and contradictions inherent in the legal self-help model, this promotion of a do-it-yourself ethos in place of substantive legal aid. The path I pursued, showing how legal self-help is enacted by tracing its practice and effects through micro-interactions, suggests a different approach we might take to analyzing and critiquing this help to self-help. Focusing on the processes through which access is defined and carried out, we might consider more fully how justice materializes in and through the practice of law, how just that practice would seem for those who actually have to engage with it. Access to justice is not something that's accomplished merely by crossing a threshold from self-represented litigant to a professionalized attorney, by righting a legal wrong. It's produced, it's sustained, it's even challenged in these practices, perceptions, and actions, and interactions of people who are seeking it. So understanding some of the logic of that process offers a powerful opportunity to uncover not only some of the critical mechanics that drive interventions such as legal self-help, but also the more general, often uneasy relationship subsisting between law and justice. I want to be clear, though, that this access to justice was not only accomplished through these meetings and interactions. Paperwork is essential to legal work, and self-help clinics function in large part to help litigants fill out that paperwork. So this conclusion of the story that I'm telling you with these additional pictures of litigants ended with a comment that was Michael made, which was, it was just a shock to me. Because, I think I'm going to trial and all. You go to court. I can bring this stuff out in trial. I didn't even make it, I'm just dealing with paperwork. This sense of being overwhelmed around in paperwork. So texts are central to the production of legal knowledge, this linking of law to an allegedly exterior world. And so paperwork is also essential to legal work, and self-help clinics are functioning in large part to help litigants fill out that paperwork. Written documents such as statutes and constitutions embody official rules. They carry them within and outside legal institutions. They're used in courts as evidence. We have written documents that appear in almost every stage of the legal process. A complainant is going to initiate a legal action through a written complaint. A defendant is going to respond in writing. Much of the evidence exchanged between parties is through writing. It includes copies of memos, emails, policies, notes that are written not for courts, but in the ordinary course of business and everyday life. Litigants shape the direction of their case. They seek to request or exclude evidence, extend deadlines, dismiss or limit legal arguments, all through written motions. So in finishing this discussion of research in a legal self-help clinic, I want to interrogate this idea of a right paper. And I take this idea of a right paper from a particular exchange that Lisa had with an appellant named Omir. And Omir says to her, I took all of the paperwork over there. I showed the judge. I told him, Mr. Judge, this is fraud. Please stop the process. And he ignored me. Always he said, he was telling me, bring right paper. And I say, right paper what? That's the letter. That's the everything you have, So I latched on to Omir's question, right paper what? Because I think it's just such a perfect question. This idea, I have all these papers, what in the world do you need? This idea that courts don't see it as a particular right paper because it's not in the form they're used to. So this concept of the right paper offers us a way to understand how participants in the legal self-help process develop what we might call legal literacy. It's an analytic tool. In their efforts to produce the right paper, litigants and attorneys are going to demonstrate not only a particularized understanding of the law, but also make plain the process through which understanding is developed and articulated through practice. So writing, this idea of writing, it's I see it as an action. My background is linguistic anthropology. I think about linguistic theory. Writing acts. Writing is doing, linguists tell us. So for example, I now pronounce you man and wife. It's not just words. It's actually doing something. It's creating a legal relation. You may also think about the different ways we might write quiet and the effect that has on our way of writing, of responding to that written command. Quiet has a particular, evokes a particular response versus quiet with this huge exclamation point versus someone who's yelling at you, quiet. All of these things are not just words, but actually effectuate an action. So this is what I'm looking at most often in the legal self-help clinic. And for them, it's not these signs or these writing acts, these pronunciations of man and wife, but they're online forms. Many courts aim to produce forms in language that's understandable to an ordinary person. So most of these are designed to be filled out. And I ask with them, what do we do with writing? And what does writing make us do? So looking particularly at these kinds of forms. Here's just an example that you'll see. I'm capturing here the forms that we see in California self-help courts, where you literally fill in the blanks. My name is, this is an example, this is my case number. Now, the idea of these forms is to make it possible for litigants to write their claims and legal arguments in ways that are comprehensible to judges who can evaluate them. This emphasis on legal forms can be traced back to the 19th century. This idea of making every man his lawyer. I have a quote here from John Wells. He's talking about, we can make a professional man, a farmer, a mechanic, a manufacturer, a soldier. Anybody can understand what they can do to be their own lawyer as long as they have these instruments in writing. And this is I think, reflected in the way in which courts are now approaching legal self-help. Recent surveys suggest that fill-in-the-blank forms today serve as the most basic and common tool on the continuum of legal assistance. Over the past 30 years, we've seen the move to a simple form with clear questions. We've seen the elimination of Latin legal terms that lawyers are so used to. Instead of nolo contendere, we see no contest. Instead of ex parte, we see without notice the other side. This idea we're going to put forms in a language that litigants should be used to, can understand. And yet these forms are still hard for litigants. Almost universally, they understand the self-help clinic as a place where they can go to get help to complete these forms. So I asked the litigant, what's the most helpful thing about being here? And the litigant says, well, she does all the work. And of course we all laugh. But he says, it's like Katrina, Hurricane Katrina, which struck Louisiana, hits you. And then the skies open up because you have someone you can go to, someone who can explain what you can and can't do with the paperwork. This metaphor of the clinic as a clearing amidst a storm highlights a commonly expressed perception of the clinic as a refuge from the antagonism, the confusion that so often accompanies litigation. So this right paper is both a thing and an idea, and my exploration of this concept moves us in and out of different discourses and practices, which I think offer a tangible manifestation of individual interactions and institutional constraints that can together give these papers the quality of being quote unquote right. I'm going to skip over this kind of close analysis I just did with the conversation because I want to make sure that we leave time for questions. But I'm happy to talk more about this in the Q&A. But this is another very close look at what's going on, a meeting between a litigant and Lisa as they're trying to negotiate and talk about the right paper. And rather than go through each of the transcripts that I've pulled for you, let me just show you a quick
The index can just say master index. This is all you really need. And then it'll say witnesses. And you can just list,
Needed my wife. Ex-wife.
John Doe.
Yeah.
And just list the, pages, 1, 2, 3, and then Jane Roe 5, 6, 7. So, and then it'll say exhibits, and then it'll be, exhibit A, and 5, 6, exhibit B, 7, 8. It's only testimony by these people. It's not.
If I don't have witnesses.
Right. If there are no witnesses,
this don't have witnesses.
Then
it's just my ex-wife attorney, my ex-wife,
yeah.
and me and my attorney.
Yeah, if it's just attorneys arguing, then there's no witnesses,
Yes.
so nothing goes in the index.
Oh, okay.
But you still need to have an index. So sometimes there are indexes that are just like blank, but you still have to have it. So it'll say witnesses, and then there will be nothing, and it'll say exhibits, and there will be nothing.
Mhm.
But you still have to have it.
I have exhibits from the trial, so I can list it. I have list of exhibits.
Were they used?
Yes.
Okay, good.
So
So this is an example of how Lisa is talking through how to fill out paperwork, in this case, attaching an index. And she's formulating her explanation as a demonstration, literally transcribing her speech as she speaks and lending the weight of this written document to reinforce what it is she's saying. She's also showing that the formatting is not arbitrary. The formatting is actually going to dictate how the index will be used. Since exhibits generally are offered as evidence for a particular kind of fact or argument, they need to be made meaningful in some way. And it's not a meaning that's absolute, but it's created by how judges are going to actually literally be going through this paper. They're going to look at this number and they're going to go to this page as she's explaining it. She uses speech to kind of tell Peter that she imports the judges into the clinic room, literally to walk him through how they are going to be reading this particular writing. And this sequence, I think, adds new information to our understanding of forms. The act of form filling raises issues that are primarily concerned with deciding what content should be written, which boxes should be checked, which items should be listed. The aesthetics of form matter because writing has to fit within these spaces that are provided. This is one of several ways that forms are and are not formulaic. Forms require you to fit within spaces, and occasionally allowances are made, for example, as Peter is doing here, attaching something because it doesn't actually fit in this particular form. So trying to produce this thing that we're going to call the right paper, litigants are entering into a play between conventions and creativity that requires them to know the rules, but also to recognize opportunities for exceptions to those rules. So I wanted to point to this exchange as a way of showing that the right paper serves as a tool for accessing justice, also a mode of knowledge production about the law. I want to introduce you to some of my research on self-help to elucidate how this writing is operating in one legal self-help clinic, where unrepresented litigants can go on to find their help to self-help. For all their aspirations to plain language and accessibility, legal forms are not self-explanatory. Many litigants would say they had no idea what to do. They have many unanswered questions. So do litigants who get assistance resolve their cases more quickly than those who don't? Do litigants who receive assistance achieve a more favorable outcome than those who do not? Are there other benefits apart from final disposition for the litigants who use these services? These are all questions I think we need to be asking ourselves about legal self-help. I want to also remind us that legal self-help services aren't necessarily the only way or even the best way to be accessing justice. This idea of writing and finding right can sometimes open doors, and sometimes it can completely shut them. Ideally, it's opening this door onto justice. But whether or not they particularly achieve that really does matter how you define this access to justice, how you define things like the right paper. I want to just talk very, very briefly about some future possibilities for legal self-help, because what I've focused on thus far has been legal self-help in court cases. The practices and processes of self-help have been determined largely by context. And the context that we have here, this model, is mainly in these clinics that are in literally courts. But what about self-help outside the litigation context? So recently I've been studying the environmental justice movement, especially how people are making claims for environmental justice. Over the past few decades, grassroots activists and advocates are attempting to change the ways in which governments are implementing health and environmental laws. And collectively, these are the efforts that we call environmental justice. The advocates in many respects resemble the majority of self-help litigants. They're self-motivated individuals who hail from what we call vulnerable communities. They're generally lower income, higher percentage minority, often living in communities overrun by industry, highways, pollution sources. Many of them have become advocates because they've experienced firsthand these problems caused by pollution and toxic waste, disease, death, terrible property values, fear for children and elderly family members. But unlike self-help litigants, environmental justice efforts happen largely outside of the courts, and for good reason. For a variety of factors, environmental justice really has not found much success in litigation. So what does self-help look like for environmental justice advocates? Well, some preliminary observations. First, unlike the self-help I've been studying, where law eclipses all else, EJ activists tend to ignore their legal rights and claims. They focus instead on moral, political, and economic arguments. It isn't to say that law isn't important, but it's often unknown to them. So in a sense, attorneys and activists working in environmental justice have a large opening for education programs. They can actually tell people how law is relevant and why. Second, the law that's relevant is not necessarily how to litigate in court. Although there's procedures that we deal with in these legal self-help clinics, the procedures that are essential in environmental justice have much more to do with administrative procedures. Environmental justice is often achieved through the notice of comment process. So this idea of informing people what this is, what kinds of procedures exist outside the litigation context. And finally, I want to say that some of the most successful environmental justice initiatives have found a way to fill multiple needs of activists. In clinics, I often marveled at how much litigants seem to need social workers, doctors, all sorts of other people in addition to the lawyers that they were consulting for all of their needs. In environmental justice, that's true too. But in generating self-help, environmental justice activists have found a way to bring all of that together through this kind of multidisciplinary collaborative. Lawyers contribute to a team rather than can constitute the entire resource. So these are just some preliminary observations, conclusions. But I think as this research is progressing, I'll have the opportunity to elaborate and extend these findings. What it shows so far is that the model of legal self-help we've generated in response to this access to justice crisis in courts is more limited than it might otherwise be. And perhaps it gives what litigants might need in that particular context. But given how vast and varied individuals' ideas of justice are, I suspect we'll see in other self-help models, such as this environmental justice one, a more efficient, more effective, and certainly more empowering mode of creating and delivering legal self-help. And with that, we'll be happy to discuss any of this further. Sorry for going over, Tomas. I'd be delighted to take any questions you have and that we have time for.